When entering into a group insurance contract, we're typically going to see the party entering into the contract, what we would call the insured in an individual case. We're normally going to see either an employer or an association or a union or creditor entering into these contracts. The one that we are generally most familiar with in this business is those employer contracts. That tends to be what we look for as agents in this business, but that's not necessarily where we should always be focusing our efforts. I'll talk about some of those other ones in a minute. But the employer, in fact, is where we normally target our efforts, just because that's, I think, who we're most comfortable dealing with. That may be where we have access to some sort of center of influence, or you go sit down with an employee, you find they don't have group benefits. You say, well, do you think your employer's ever thought about it? Maybe they haven't. Why don't we go sit down with them and show them that there are ways that we can manage a group contract where it's affordable and competitive. Now, that being said, there are folks who make a great living in this business dealing with nothing but associations. And some associations enter into group insurance contracts where there tends to be maybe less coverage than you would find in a typical employer group. Those associations might be looking for just one or two sorts of coverage, possibly accidental death and dismemberment, which is pretty common through association plans. Maybe disability insurance, also pretty common through association plans. You might find travel insurance increasingly is something that we incorporate into association plans. So when you look at somebody, you see an individual who's lacking a certain sort of coverage. If you're imaginative, you might say, well, really, does your employer have the opportunity to offer that coverage, or does an association to which you belong offer that sort of coverage? You can really take this small need, this individual need, and recognize a much larger need, which might allow you an opportunity that you wouldn't have otherwise had. Unions are another one that acquires insurance contracts. The very large trade unions will typically deal directly with insurers, but you might find a smaller union from time to time that needs coverage. An example that's not often thought about, that does often have some insurance contracts in force, is students' unions. So students' unions will typically have insurance contracts. It might just be for health and dental or accidental death and dismemberment insurance, but there's typically some sort of coverage there. And then creditor insurance. This tends to be a fairly specialized market, and these tend to be fairly specialized products. But if you look around, you will find opportunities here as well. So an area that sometimes causes confusion for agents who are very used to individual life insurance business is the actual participants. So the plan members, the employees, or the union members, or the association members, they are not actually going to be parties to the contract. They do not have what we call privity of contract with the employer. That means, with the insurer. That means that they are not bound to any sort of contract with the insurer. The insurer will provide them with a benefits booklet or a certificate of insurance describing the coverages that are available at the time the plan is put in place, but that's not a contract. The contract here, if there is one, is between the plan members and the employer, or whoever the plan sponsor happens to be. That's what we looked at in the previous slide. That employer, association, union, or creditor is what we would identify as the plan sponsor. And it's the plan sponsor who really has the responsibility for dealing with and communicating with the plan members. Now, that being said, if you're going to provide meaningful service, you're going to take on some of that responsibility, or you're going to help the employer to meet their responsibilities. But really, it is the employer who's responsible for whatever communications happen with the plan members. I wouldn't suggest taking on a group contract where you don't have some intention of helping out with that service. So now that we have this opportunity to enter into a group insurance contract, let's have a look at who belongs to the group. So one of the really great things about group insurance is that it's very easy to get covered under these plans. Typically with groups 5 lives or more, there's not going to be any individual underwriting on the basic coverage available within the plan. We'll talk about that in a moment. So this ease of getting covered, and we'll talk in the next 2 slides about just how easy that is, makes the group plan quite useful. People who can't get coverage elsewhere, for example, but belong to a group will find that they have coverage here. People who've never thought about getting insurance will find that they have the opportunity to get coverage here. On smaller groups, if you do have smaller groups, you will sometimes have a requirement to go and do some underwriting. If you have a group of 2 or 3 lives, for example, the underwriting might not be a whole lot different from what you would find with an individual plan. We do have some limits on the coverage that's available. So we have what's called a non-evidence maximum. The non-evidence maximum means that that's the limit to which the insurer will provide coverage without seeing some sort of medical evidence from that plan member. And that makes sense. The insurer is taking a risk without knowing who they're dealing with. They can't take an unlimited amount of risk. And then beyond that, you'll typically have a plan maximum as well. And that plan maximum would typically be quite a bit larger than the non-evidence maximum. That would be the upper end of the coverage available. It is important to understand that non-evidence maximum. A lot of people figure that they have some amount of, let's say, disability insurance in place based on they know their plan covers them for 66 2/3% of their monthly income or whatever you have, never having realized that their plan has a non-evidence maximum, which means that if they haven't gone through medical underwriting, they're not actually going to have sufficient disability income replacement. Hand in hand with that, you find that generally speaking, in smaller groups, you're going to have lower limits. Larger groups might have larger limits simply because they have more leverage when dealing with the insurer. Now, that being said, if you're willing to pay for the risk, smaller groups can get fairly substantial non-evidence maximums. NEMs is what they're often referred to, and quite large plan maximums, but there will be a cost. So, because there is no underwriting with group insurance, we have substantial concerns around anti-selection. Anti-selection is, of course, a term that those of you with a strong insurance background will know. Basically, anti-selection is a situation where somebody is able to acquire insurance even though they have a risk in place which should probably prevent them from getting insurance. We would say, for example, that once your house is already on fire, it's too late to buy insurance. That's anti-selection. So the insurance company is going to look to limit their risk in a few different ways. We talked in the previous slide about those non-evidence maximums and plan maximums. Those are one example or 2 examples of mechanisms that insurers put in place to limit their coverage to avoid anti-selection problems. The actively at work provision. In the absence of any kind of medical underwriting or financial underwriting, the insurance company is going to have some way, or going to look for some way to make sure that the people who are getting covered should be getting covered. We don't want to cover somebody who can barely crawl out of bed in the morning. So the way that we avoid that is we say, in order to start onto a plan, you have to be actively at work. We make an assumption that once that person is actively at work, that means, hand in hand, that they are in good enough shape to be covered. We all have pre-existing condition limitations, generally only on the disability portion of a plan. There are some possibilities with higher-end health and dental plans, such as orthodontics or major surgery, to have some limitations here, but not that common. Really what we're looking at with these pre-existing conditions is, did you receive treatment in some period prior to the start of the plan. And if you did, then we're likely going to exclude a disability related to that specific treatment for a set period of time afterwards. We'll look at that again when we talk about disability insurance later on in the presentation. But you might see a limitation here that would be something like, let's say, 90 and 12, which would mean if you had received treatment in the 90 days prior to the start of coverage, that you would not be able to successfully submit a long-term disability claims in the 12 months after coverage starts. Now, if it was something unrelated to the treatment you received in the 90 days prior, you'd still be in good shape. You'd still be able to submit that claim. That is a fairly generous provision within group disability plans. It does mean that people are going to be in potentially rough shape but healthy enough to work and still get disability coverage, which could even end up covering them for their pre-existing condition if they work long enough after going onto the plan. And we do have minimum levels of participation as well. The insurers are going to want to avoid a situation where, let's say we have a group of 20 lives, and only 10 of those people want to participate. Well, the insurer might look on this with some suspicion. They would say, who are the 10 people that opted out of the plan? And what you'll probably find is that the 10 people who opted out of the plan are young, healthy folks with no kids. Some of them will be people whose spouses have coverage and they don't really need coverage, or they don't think they need coverage as a result. But the insurer then says, well, the 10 people that are left on the plan, the 10 people that stuck around, they're going to be a problem. They might be older or in poor health. They might have family history. They might have kids who have some sort of need for an unusual amount of coverage. So in response to that, the insurer says, with any group, we're going to look for at least 75% participation. We don't want to have groups where we have such small numbers that we're convinced that we're only going to be stuck with the bad risks. We want to make sure we have some good risks to go with the bad. And sometimes in order to meet that minimum 75% level of participation, employers will put in place terms of employment that say, if you're going to work here, you have to join the plan. That's a perfectly legitimate thing for an employer to do. Employers can make it mandatory for their employees to belong to the plan. So once we get into actually structuring a plan, what we typically call plan design, we're going to determine who in the plan is going to get what sorts of coverage. We will break this down by class normally. You have to be very cautious about how you define classes. We are not permitted under human rights legislation, sometimes employment legislation, depending on the province, to make discrimination based on age, sex, race, level of income, disability, religion. These are typically all forbidden under human rights legislation. So if you're building a class, you have to identify that class in some other way than these prohibited grounds. An example would be duties. So you might have one class that's all managers and another class that's all employees. That's okay, as long as we can make a clear distinction between the management and the staff. So from Saskatchewan in the early 1990s, we have the leading case on discrimination in group insurance contracts. This case helps us to identify where there is discrimination on one of these unjust or even illegal bases. What happened was Ms. Gibbs, this woman in the employment of the Battlefordson District Cooperatives, she became disabled. Her disability was stress or some other mental disability, and she ended up going on claim. Now, once she was on claim, she found that her benefits ended after just 2 years, when everybody else on the plan would have had benefits until age 65. This was not a pre-existing condition. She hadn't had stress in the year prior or whatever the case is, so there was no opportunity to enforce some sort of pre-existing condition clause. It was simply the case that she ended up with a disability that was deemed to be a mental disability. And you'll sometimes see these identified as a disability with no organic cause. It means that we can't identify some sort of damage to the body or whatever the case is that caused the disability. So she has this mental disability, and she ends up suing her employer, Battlefords and District Cooperatives, and says, look, I'm supposed to be covered just like everybody else here. This is contrary to human rights legislation. You are discriminating on the basis of my particular disability. And she won. She did end up winning. And what this should lead to, and has generally led to, although you'll see the occasional quite risky exception to this rule, is that we no longer have the opportunity to treat a mental disability differently than a physical disability within group insurance contracts. Certainly that's still possible within individual insurance contracts. In individual insurance contracts, we're not governed by human rights legislation. There's not that employer-employee relationship. Now, at the same time, just because I know that sometimes this concern comes up, in that particular case, the judge who wrote the ruling did suggest that it's still okay for insurers to discriminate on the very normal bases of age. How do we discriminate based on age? Well, we charge a higher premium for folks that are older, a smaller premium for folks that are younger. The judge reaffirmed that those principles are okay. That's simply a matter of risk management. So even though that is based on age, it wasn't seen to be contrary to these provisions of the human rights legislation. Now, notable here is that it was not the insurer who was found to have been the problem, it was the employer who was found to be the problem. So the employer is the one who ends up settling the claim here. It may be the case, we don't know, that the employer did seek some sort of compensation from the insurer. Perhaps there was an out-of-court settlement, but we don't know that. What we do know is that it was the employer who was found liable. This is the privity of contract that I had spoken about earlier. That is, there's no contract or no agreement in place between the employee and the insurer. The only agreement that's in place is between the employer and the employee. So if there's a problem with the coverage, the employee is going to come after their employer. That's the party with whom they have that privity of contract, for the most part, with respect to group benefits. That means that as the agent, you have a responsibility to make sure that the employer gets benefits that are most appropriate for their circumstance and understands the consequences of those benefits. It also means that you should be working with those employer groups to make sure that they are taking good care of their employees. Things like entering in their data in a timely fashion and enrolling employees on the date that they become eligible for coverage.